I'm clocking out. I'm out of here. Because we gonna be here all night. You know that, right? You know that, right? We gonna be here. And I told she, yes. Let me tell you why I said that. Their trial safety was cut and dry. How about the jurors was out 6 hours? They came back as charged. Why the fuck was y'all like that all that long? I know, but we had a lot of money. Yeah. Okay, I'm gonna give you that one. You can have that one. Because see, my mama cooked. I asked her if she wanted me to help, but she was like, no, because you working so hard in it. No, she said no because I'm in this trial. Because any other time I would help her cook Thanksgiving. And she was over there saying like that. And I said, Mama, you go Thanksgiving. You want me to help you? No, because you working your ass off in this trial. I'm not going to cook a whole lot because we leaving town in next day, so don't worry about it. You just get your rest. I said, okay. Because normally I help her cook because we get off early on the days on Thanksgiving. She said, no, nothing. I tell her how many hours I got. She was like, yeah, you was working your ass off. What happened? She come in smiling. Did you win lotto?
Of course, it's always happening.
Thought you won lotto.
No, just...
You came in smiling.
Okay, so back on the record with the state defense and Mr. Medina present. Okay, did somebody find the lesser included for child neglect?
Yes, Judge. We have no objection to culpable negligence being added as a lesser to child neglect.
8.9, Judge.
8.9, okay, so I'll pull that in a moment.
Right.
So that will be added, but the lesser included for throwing a deadly missile will be taken out. Okay. So that will take us to...
So just to be clear, the lesser indicated of shooting and throwing a deadly missile, essentially it's going to be changed to neglect of a child, and the lesser is culpable negligence.
No. The lesser, that's confusing. The lesser included indicated crime in the definition of shooting or throwing a deadly missile will be removed. Then a new sentence that says the lesser crime indicated in the definition of a child neglect, no great bodily harm, as charged in count 3 of the indictment, and it needs to be changed from information to indictment. All of these sentences will be culpable negligence, and then we'll add that in for our next run through these instructions.
Right.
Okay.
Judge, can we go back just briefly to first-degree murder?
Yes, sir.
I just saw something, but I'm not sure why we're on the second page of the definition of first-degree murder. I'm not sure why we're defining dangerous weapon at the bottom there. Is that... I'm not seeing dangerous weapon anywhere prior to that, so I'm not sure why we're defining it there.
I pulled these all off of the Supreme Court website, so you know that they're just
Yeah, that's not an element of first-degree murder.
instructed, so let's take a peek at it.
Judge, I'm also looking at the Supreme Court.
I'm looking at it.
I don't see it as
It
well.
might have just been a...
There's a separate instruction for enhancement for carrying a firearm, but that's a separate whole instruction.
Right, and that's
not here.
Okay, so we'll take out, thank you for catching that, we will take out the definition of dangerous weapon. And I apologize for that. Okay. So, going back to 7.4, second-degree murder, taking out the statute number. Any alterations, changes?
Just delete the sentence that says, give only if there is evidence that the defendant acted in heat of passion.
Okay.
I agree.
Other than that, good to go, State?
Yes.
Just that one sentence.
Right, with that deletion, is that fine for the defense?
Oh, for the defense, yes.
Okay. Then we'll go to 7.7 manslaughter, taking out statute number.
That's our statute number towards the bottom.
Yes.
But I think negligence can be deleted. If it's manslaughter by
It
negligence.
would be manslaughter by negligence. So, defense, do you agree that the definition of negligence can be taken out?
Yes, Your Honor.
Okay. Any other alterations? And there's also under justifiable homicide, there's a statute number which I will take out. Any other alterations to the manslaughter instruction?
No.
No, Your Honor.
That is going to take us to 3.6F, justifiable use of deadly force. Okay. We have a lot of talking to do here.
Yes.
Maybe save this one for last.
What? Say that again?
Maybe save this one for last.
Okay, so let's save this one for last. Okay. That is a good idea. Okay, so let's just skip that one. We'll go to that one. Then it's 3.12A, single defendant, multiple counts or information. It'll be indictments, non-information.
Are we 3.112A?
Yes, 3.12A.
Right, by indictment.
No objections.
Okay. And obviously I'm going to take out the forensic and make it as to the other crimes charged in the last sentence. Any other changes or alterations, state or defense?
No.
No.
Okay, evidence of other crimes, wrongs, or acts?
No objection.
Defense?
No objection.
Okay, 3.7, plead not guilty, reasonable doubt, and burden of proof.
No objection.
No objection.
3.9, weighing the evidence. Even though we haven't completed taking the evidence, are we going to have paragraph 9, any witnesses who've been convicted of a felony, misdemeanor, dishonesty, false statement?
I don't anticipate so.
Defense, would you agree taking out number 9 at this stage?
At this stage, I agree.
Okay. Any others we can agree to take out at this point, or we're just going to hold on until the last minute?
I don't think there's been reputation evidence, Judge, but
Defense, are you ready to be heard on that? General reputation evidence?
Judge, we would like that at this point.
We'll talk about that at the final charge conference.
Okay.
Obviously, law enforcement witnesses stay in. I will change it to be his or her because we have had both. In this case, we have had expert witnesses, again, both his and her. Child witnesses, we have had that. We'll hold off on defendant testifying, not testifying, witness talking to the lawyer remains. Anything else needs to be changed today?
No.
On this state defense?
No, Your Honor.
Okay, let's go to, we'll skip 3.9A, we do not know. Defendant statement, 3.9B. We do have a statement made by the defendant in this case. Any objection, state?
no, although on my copy, rules for deliberation seems to be encroaching at the bottom there.
All right, I'm going to make all the pagination changes.
It's gonna be pretty.
I'll make it pretty.
It's gotta be pretty.
I'll make it all pretty. Okay, so any changes to defendant's statements?
No, Your Honor.
Okay, how about 3.10, rules for deliberation? I'll take out the parens in paragraph 2 for their and have seen in the form of exhibits. Any other
objection.
changes?
No objection.
Okay, that will take us to 3.11, cautionary instruction, my
No
favorite.
objection.
No objection.
Okay, 3.12, verdict.
No objection.
None.
Okay, then we have the enhanced, well, let's skip the enhancements and then we'll go to 3.3, submitting case to jury.
3.13.
We're gonna have an issue, which is in this courtroom, as in most in this building. They cannot get the TV in the back, and because there seems to be. So what I generally do is, for the portion that talks about evidence that says that.
Wait, what number are you at, Judge?
We're on 3.13, submitting case to jury, talking about the evidence going back with
Judge,
them.
we don't have that.
You don't have that?
No?
I'll share.
It might be in the middle of some of the.
I'll share with them.
Okay. It might be in some of the. It's after 3.3D. Oh, for some reason it did not print out.
It says here, submitting case to jury on the bottom.
Oh, it's at the bottom. I'm sorry,
See
Judge.
it?
Okay, I apologize again. That
My
was.
formatting is also just off.
Here, submitting case.
I have it.
I did warn you I'm having problems with my computer today. So we're lucky we got it at all. Okay, so generally what we can do is say. That's comforting.
That's a false one.
Generally okay, well, so we have a few issues here. Number one, that the video evidence is just incapable because of the tight squeeze
Right.
in this jury box. It can't go back. And number two, we also have a firearm. Let's deal with the firearm issue first, because I think that that's probably the easier one to deal with, which is that,
When I send it.
how do you all want to deal with that?
Judge, I've usually just told the jurors that when and if they want to view the video evidence, that the court.
Well, I'm talking about firearm
Firearm.
first, and then we'll go to video.
Oh, the firearm.
Yeah,
I'm
the
sorry.
firearm,
That they should be told that the firearm will be here if they want to see it.
Okay.
It will be kept out with the clerk or whoever, and if they
Because
want to
I
see
know
it,
when I send it.
they can make a request to see it.
Well, actually, this is one of those cases where they don't have, it's not where a firearm was found with
Case.
live ammunition.
It wasn't. There's no live ammunition
So,
in
and
it.
it's in
That
a
is
safe
correct.
position, so
It has been
do you
made.
want it to go back state?
Assuming
defense?
no jurors bring their own bullets, then I guess we can get it.
So I guess we could send it back with gloves, because I know you all wore gloves. We can do that. I'll take your suggestions for the firearm, for
That's what I
the
thought.
bullets,
No.
for the casings, or the projectiles, rather than have biological matter. You all, how would you propose dealing with that?
I always keep them separate.
First of all, they need to be kept separate.
I always keep them
Meaning,
separate,
firearms
Judge.
cannot go back there
Right.
at
With
the
the
same
case.
time.
Right.
Exactly.
I know
That
we
has
do.
to get back here, and then we
Exactly.
switch it out.
Correct. That's how I do it.
Exactly,
I
and then if
switch
they
it out.
want to see it, they can put on gloves.
Yeah.
You're not good?
I switch them out.
They're ready? Oh, okay. It's a
Yeah.
false alarm? Okay.
I
So
don't-
have them ready in 5 minutes,
I
Jose.
never
We're
send
just
both
dealing
of them
with one.
together.
Okay, go ahead.
I never send both of
Right,
them
so
together.
never.
Judge, I never send both of them together. I send the firearm and I keep the
Oh, I agree with
ammunition.
that, but
And then when they want it, we switch out.
we cannot send them either back, or just say any of these items are available for your review, just send us a note.
Judge, I would prefer B. You know, every juror's got that. I don't know. I don't like the idea of sending a firearm back
Okay, we
there,
don't
with
have
all
to.
due respect.
Okay.
I don't have an issue with leaving it here, and if they want to see it, sending a note out to see it.
Okay. And Mr. Dunn, you were gonna make a proposal related to video?
Yes, Judge, just to instruct them that if they wish to see the video, they can do so in the courtroom. The courtroom will be cleared for them, and they can be here by themselves, play it as many times as they want. We've got several discs, so.
Let's do this. I will make a proposal as to the language that we will include in the instructions, and I'll provide it to you sometime later today for your review. Okay? And we'll
Okay, so it's
take,
going to be language on the firearm and language on the videos.
right, correct.
Yeah, it's out there.
Okay. So why doesn't everybody just go ahead and get in places? We'll deal with the remainder in a bit, but let's get these jurors on their way.
And Judge, again, Detective Verano is here, but I don't want to do something in front of the jury unnecessarily. If the defense has an exhibit that they expect them to authenticate,
Yes.
then
I have 3 exhibits. I have a copy of the CD that
You want to go talk to him? He is your witness. Why don't you go talk to him before you put him on the screen?
we should do that.
Somebody want to come with me?
Yes.
So you never talk to him. So I guess the copy can go back.
Right.
talking about the firearm and projectile.
Right, I never sent both of them back
So what I'm
together.
saying is, many of these exhibits will be sent back to you, sent into the jury room with you when you begin your deliberation. If you wish to see the firearm,
You can request for it.
projectile,
You can't go both back
Right.
together.
well, I'm not going to tell them you can't go
Right.
back together. If they request them both, we'll say, due to courthouse policy,
Right.
we'll write them a note. Courthouse policy.
And they can
You
ask
can't,
them.
we'll send them when you finish reviewing this,
bring
please
it.
knock on the door.
And you get the
return
other
that
one.
and get the other.
Yeah, I never send both back
No, I
at the
agree.
same time.
I agree.
Okay, this is TV guy. I'm about to put this on the floor because I can't see you. I'm about to put this on the floor. I can't see you. Girl, when I go upstairs, when you like, Mother, you got something for me to do because I'm finished for the day. And she said, no, so it's at 1 o'clock. I gotta go home. Because I'm going to be here all day tomorrow. I got to be here. I will be closed tomorrow. Go ahead. Yeah, I do. Because I don't want to be bothered with this noise. I forgot about you.
Judge, I'd ask for permission to allow me
Well, wait, I
to...
need a state attorney, I can't.
No, he's right.
Oh, okay.
They're with the detective. I need this detective to be able to authenticate these three, and he won't be able to do it unless he sees it. So with the court's permission...
absolutely. He can come
Outside
in.
of the... Come on in.
Detective, thank you for coming under such short notice. We both the state, the defense, court, and I'm sure the jury.
Give me 1 second, Judge. Oh. It's on page 63. It's this little thing. So here are the and these are the three I'm going to... These are what they sent us in discovery, which is, I believe, I don't know what the exact terminology is, but they're on page 63 of that CD. And that CD we burnt from the exhibit the prosecution gave us.
No, you never know. And we'll be hitting it next year.
It's his computer to break against more than the defense. Yes. It's so funny, my mom.
You see, William Tucker got a homeboy case because he couldn't. Yeah, let me know because I'm real good. Yeah, you please do because I'm going to still be your girl when this thing comes back. Yes, I am. And if it comes back when I'm still here, I'm going to do that shit to you. I'm going to say, you can have his phone. I'll do that.
I'm not going to use the right. Okay, so
Oh, she's send it back.
I don't know what it's been.
Yeah. And I ain't never with
The only difference is that little black dot. I'm sure the prosecution's point of this issue. Yeah, I know. That image on what you were given was that image appeared to be altered.
What's in it what's on it? I can't tell you if it's true. I understand. I'm saying that what it's similar to ritual what's in it. And position.
Well, they should have learned to ask effectively. You are right. They don't need to be. I know there's direct things. Must be created on it. No, but he created what's on the CD. He just gave us, and he gave us on Friday night.
I'm not going to see that. I'm not asking. I didn't make things funny. All I can tell you is that visually looks similar to that.
He created it and had neighbors. Well, Judge, I need to raise an issue.
On the record, the state defense, Mr. Medina, are present.
So, Friday, after court, the prosecution amended discovery because they had Detective Ruano go through the disc that Mr. Coleman created and do a screen-by-screen analysis.
Not correct, but I'll correct it.
I'll let him correct that. Go ahead.
No, you go ahead.
They then provided us a amended discovery.
Yeah, wait, you know what, let the witness step out just so.
It's fine. They have then subsequently amended discovery, which we adopted yesterday. They amended discovery Friday night. We adopted it Sunday night. Okay? So within 48 hours of authenticating that these images are consistent with what our expert produced, we adopted what they listed. We have had Detective Ruano listed as a defense, as a defense witness for quite some time. We then printed out the images that he created, and he is now indicating that he can't authenticate these because he didn't create them. Judge, I'm asking, the only thing that he can authenticate is what the prosecution has in their custody. I need that for him to be able to, I've made a copy of it, I've showed it to him, but he can't authenticate it. I'm asking for leave to be able to have possession of the actual original so I can authenticate it.
I can't. You can have access to what is in evidence.
Okay.
Judge, Detective Ruano did not work off of the evidence created by Mr. Coleman. That's what I wanted to clarify. Detective Ruano created a disc for me at my request, which I'm holding up. This is my disc. It's my work product. He created this from the original footage on the master disc that's in the police department file on this matter. He went to the source material, so to speak, and he created certain still images for me of a particular portion of the video. And he put that on this disc, which is the only disc as far as what he tells me, and it has his name on it, his police case number, his badge number. He could authenticate this disc. If I were putting this on, he could do that. He did not create or print the still images that defense counsel is seeking to remove from him. He did not create the disc that defense counsel burned from what I emailed them on Friday evening. So really the problem the defense is in is that they're attempting to use the state's experts to prove their case, and that's not generally how things are done. They should have had this done by their expert, and now they're in a situation where the expert they're trying to use can't authenticate what they need because he didn't actually create it. What we're looking at is still images with nothing identifying them. Nothing to say what exact second they come from. All Detective Verano has is defense counsel's representations that I printed this from the PDF you sent to state. But Detective Verano doesn't have any verification of that. He can't inspect anything that would allow him to testify under oath that that's true. And so he has rightly said, if I needed to authenticate something, I could authenticate your disc, Mr. Dunn, because it's got my name and my case number.
I can't order the state to turn over
Judge,
the product.
I understand that, but they have a discovery obligation to turn over what they have to us. So they sent it to us. We are now asking for they sent us a link where usually we print out, which is what we've done, okay? What the normal course and policy is with CDs is we sent them a blank CD and they would burn it. But because of the time limitations that we have, we took it on our own accord to do this. Judge, it's time stamped, Channel 1, 7:33:33. It's right.
Mr. Dunn, I understand what you're saying, but ultimately you're in the defense's case, and you have to present your case. This is your witness. If your witness can authenticate the item, even though he was originally listed as a state witness, so be it. If he cannot, he cannot. You're at this point, you're barking at the moon. There's nothing the court can do to make this witness be able to authenticate an item he's saying he can't authenticate.
What I'm asking for is, Judge, I'm asking for justice here, which is what's in the prosecution's possession, for them to make a copy for us so I can use it. So it'll have the appropriate markings.
I can't require the state to turn over the work product, just as I cannot require the defense to turn over
It's discovery,
work product.
Judge. It's discovery. It's not work product. It's discovery. It's discovery.
And we emailed it to the defense Friday evening, Judge. We emailed the file to the defense, but the files themselves, in order to be admissible in court, have to be authenticated by the person who created them.
I'm sorry, Mr. Dunn, take one step back. What did you send to them on Friday?
We emailed the defense the contents of the files. That's the amended discovery, and it was done in response to the late discovery we received by them, respecting this time period.
So then you are in possession of it.
But we cannot, the detective cannot authenticate those files from his disk. He can only authenticate what he himself has created, is what he's telling us. He created
Wait,
this.
now I'm confused. Let me ask you this. So you sent what's on that disk.
Correct.
Which you're saying is work product.
No, I didn't say it was work product. I mean, what I meant to say, it's my
Copy.
disk. It's my copy. I don't have another
Okay.
original
So
to
you
give to
sent
them.
the contents of that disk.
Correct.
That is the only copy in the possession of the state to the defense.
Correct.
So why can Detective Rwanda not authenticate that work that has now been provided to the defense?
Because what he's looking at is a printout, which defense counsel is telling him these are 3 of the still images from the PDF, but there's nothing on these that would confirm for him they are. They're just
So why can't you
printouts.
pull up what you
I
provided?
did. I took my CD that we burnt, and he goes, I don't know what that is. That's what the detective said. I understand what they're doing, Judge. And I go, listen, this is what the prosecutor gave us. I directed him to exhibit number 63, 64, 65, which is what these are on what he did, of the 3 stills. And he's like, well, I don't know what that is. I mean, it's semantics, Judge. I mean, I hate to say it like that. It's semantics, and it's what they gave us.
There's 151 or so still images. And the detective is saying, I don't know that this is number 63, 65, 60, 59.
But he can say that is his work?
No, he can't. He can say, this CD that I have is his work. He can say, this is his
Well,
work.
that seems a bit disingenuous. And you burned that exact copy.
Exact right here. And he could take mine and compare it to his. I mean, listen,
So why
But
don't
he
you-
compares things forensically, Judge. He doesn't just look at the file names. He compares things with his actual equipment. He's a video forensic
But
person.
state, let's be real. You provided this discovery, and if he won't accept that discovery as his own work, then how is that fair? Fundamentally fair?
Judge, it's not a question of fair. If the state wanted to put this into evidence, we could put it into evidence. If the defense wanted to create something like this for themselves, they could have done that. They're in this position
But
because...
apparently they did.
No,
Is that the
Judge.
disc that you're showing to me, Mr. Zidane? Is that your disc, or whatever you were just showing me? Is that the disc that you burned from the...
100, we made 2 copies. There's 2 copies of it. They're the same exact thing.
It's one file that's on that disk. One file from the hundreds of files that the state sent to them. They've taken one PDF file, apparently they say, and they put it onto a disk, and they print out some still images from that disk, and they're asking the detective to say, this is what you sent the state. And the still images are just that. They're still images. They have nothing identifiable on them for him to say, yes, this is what I sent you.
So are you saying to this court that if they go and they burn it in exactly the same format that you provided it, then Detective Ruana is going to be able to come here and offer a different answer to the questions related to authenticity?
No, what I'm saying and what Detective Aranda was saying, I should clarify, it's not me saying it. He's telling me I could authenticate a disk I created, which has my identifying information on it. I can authenticate that if I needed to. But that's the state's evidence. We created this with our expert. The defense is in this position because they're trying to use the defense of the state's expert to present their case. And that's not how things are done. They have their own video expert.
Okay. So do you want to go talk to your expert, your witness, since he's also listed as a defense witness, about creating a similar CD for you?
I'm going to have to. Judge.
Go talk to him about it. See how long that takes.
Your Honor, I spoke to Detective Ruano. He indicated for him to create a copy, he would have to go back to his office, burn it, and then come back, which would take a few hours. What I would recommend is to take the CD that he created for the prosecution to see if there's a way for him to burn that here. I know that could. My expert was able to do that using a CD burner on a laptop. And then he could review it to see if it's the same thing. I'd hate for him to have to drive all the way to Doral, spend a few minutes burning a CD and bring it back. If he could do it here, if he has the ability to do that here.
Okay. This is what we're going to do.
Judge, we're happy to have Detective Aranda if he's comfortable burning it back at my office in his presence. I don't know if he's comfortable doing that. I'll talk to him if he's okay making a copy of what I made or what I have.
So either it's going to be that or he's going to have to come back tomorrow. So I'll leave it up to the detective.
Judge, the detective says if the copies are made in his presence from the master disk you gave me, he's okay authenticating them.
How long will that take at your office?
Defense counsel will tell me which files they want burned onto the disk, and we'll do it.
Just in an exercise of caution, Judge, if he could burn all the files, I know that the difference between one file and 152, it's...
You're not putting all of them into evidence, are we? Because once the list goes in, then the jury has access to all of them. So that means all of them are going into evidence.
Right. All of them, right? Right, Judge, it's just a PDF file with 153 pages. In essence, what we provided on discs. Here. You want me to show you, Detective? Huh? Okay. It's one PDF file with 152 or 53 still images. That's what we'd be asking for him to do, Judge.
Okay.
All right, he needs to see it when it's done, so I need to take him back, Judge.
Okay, let's bring in the jury. We'll tell them we'll see them here at 1 o'clock.
Please rise.
Please be
may be
seated.
seated.
For the record, the State Defense, Mr. Medina, are present. Ladies and gentlemen, I have to apologize to you all greatly. An issue has arisen that requires me to take a lunch break at this time. So I'm going to ask you to be back at 1 p.m. this afternoon to continue. Please remember my orders and instructions. As always, I greatly apologize. Thank you.
Please rise.
Please be seated. I'll see everybody here 10 to 1.